it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. Morning, are you Caden Fontanet? And this is 25 DCCR 1759. Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. The state is, Judge.
Are there any additions or corrections to the report?
Not from the defense. Not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence.
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So
Okay.
I need to call my custodian record. With the court's permission, first of all, I'm offering states one. No, Judge.
Make that states two, because this one was the plea admonishment documentation, please.
Judge, I think that's all I wish to publish unless the court wants to see the entirety of the video.
I think that's enough.
Okay.
Oh, would you switch that back to the other?
All right, I thought I did. Yeah, back on camera image.
Would you like to?
Oh, you want to flip?
Try one.
Okay. Well, HDMI one is a laptop.
HDMI two. Any other evidence or witnesses?
So just brief argument if I may.
Any other evidence or witnesses for Mr. Rojas?
No, Your Honor, just
Mr. Rojas, you may make argument first.
Thank you, Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. And what we're here asking for this morning, Judge, is probation. Mr. Fontainet's defense, he is a young offender. I know the court is tired of hearing the same story over and over, young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, trying to pay some bills, keep the lights on. Certainly, there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontanet that. We've got options here, Judge. We can send him to prison or we can put him on probation. Certainly, he's on the road. If this conduct continues, he's on the road with prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer. Because it'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take. Planning on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison probably for a longer time.
All right, thank you. What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all of that stuff's fine, but you judge where the rubber meets the road. You are that person that can protect the community from somebody like this defendant you are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Uh, uh, Judge, I'm just asking. I'm not in the habit of begging, but on behalf of this community, I'm begging that you sentence this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're gonna pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club apartments who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
Thank you, Mr. Coleman. So, Mr. Fontenette, there was a time some years ago that there really wasn't even a question. Everyone, state's attorneys were recommending youthful offenders, probation. Let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that that person had that was working in that store, that he now has, just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. Come on, Mom. Here. I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenette, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better. That's going to be up to you, okay? You can go back with the bailiff. Good morning. Are you Paul Jackson? And Mr. Rojas, will your client waive the formal reading of the indictment?
Hey, William.
Mr. Jackson, in clause number 26, DCCR 0112, you're charged with a first-degree felony offense of aggravated robbery. And that's from January 5th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Free.
And are you pleading guilty because you did what they charged you with?
Yeah.
So I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. It shows me that there is no agreement in your case and that you're leaving your punishment up to the court. Is that correct? So you're wanting probation. The state is asking me to send you to prison. It'll all be decided when we come back here later. And I look at the underlying offense. I look at any evidence that your attorney brings me, anything that the state brings me, and then I can decide to sentence you anywhere in the range of punishment, which is from probation up to between 5 years and up to life in prison. Do you understand? Do you understand?
Yes.
And there's no agreement, which means you would have some rights to appeal depending on how that goes and what I do. Do you understand that as well?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. I also want to make sure, Mr. Jackson, that you understand you have an absolute right to have a jury come in and determine 2 things. You can have the jury determine if you're guilty or not, and then if they find you guilty, you can leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? So you can either do what you're doing today, that you've signed on the paperwork and leave your punishment up to me, or you can go to a trial and let a jury decide. Okay. Is there any evidence that Mr. Jackson's not competent?
No, Your Honor.
All right, then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
I'll ask them to speak English, so I'll translate.
Thank you very much. Argelio Arellano. I'm sure I did not say that even close to right.
What did you say? I didn't hear you.
That I try.
You gotta do it, man, Judge.
Hmm.
You gotta do it again.
I know. And for the record, Mr. Rojas, you're going to translate for us. Is that correct?
Yes.
Good morning, sir. Are you Argelio Arellano?
Yes. Good morning.
Oh, me contesté en español.
Oh,
Eso está bien.
sí.
Yes.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Arellano, in cause number 21-38292, you're charged with a 3rd-degree felony offense of smuggling of persons from July 28th of 2021. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes. Yes.
Do you fully understand them?
More or less.
Well, let's go through it. Do you understand that if I follow the agreement that you made with the district attorney, that you will not be able to change your mind or appeal your case?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
Is there anything else that you don't understand that you want to ask me about?
Well, that's all.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Arellano is not competent?
Oh, yeah.
Right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of smuggling of persons. Sentence you in accordance with that agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed. So you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish. Please read it carefully because possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Okay.
All right. Good luck to you, sir. You can go back with the bailiff. Thank you, Mr. Rojas.
Thank you, Judge.
Still nothing from Mr. Bynum. Yeah, that was. Thank you, though. That's sweet. All right. I wonder if anybody's here. Is anyone here for Louisa Magruder? Just in the audience? We're just trying to figure out where her attorney might be.
I have not.
Okay.
Not from the phone or.
Is Mr. Lewis back there working on some stuff? All right, we'll just let him work on. Good morning. Are you Sebastian Cepeda?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Cepeda, in cause number 25 DCCR 0310, you're charged with the state jail felony offense of theft from a person, and that's from February 5th of 2025. And how do you plead to that charge?
Guilty, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, you go over them with Mr. Lewis.
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Cepeda is not competent?
No, Judge, there is to competency, but I was made aware after speaking with his mother that there is some mental health issues where he has not done his medication.
Okay.
So as far as any.
We'll make sure to make that part of probation. Okay. Is there any restitution?
Judge, we sent our standard, the short answer is no. We got our standard restitution letter and we did not receive a response back.
Okay. Any reason not to waive the pre-sentence report? Do you anticipate that there would be based on the facts? Let me look at this.
Well, Judge, the allegations are that this defendant was in the process of a theft from a vape store, and in the process he pulled the clerk. Yeah, it's not that egregious.
I'm just saying, but they didn't, nothing was actually taken, so there wouldn't be restitution. So no reason, no history to speak of that I need to be
just some
concerned about.
juvenile history, Judge. He does have a couple of pending cases in Refugio County, but as far as I know, they haven't been adjudicated.
Okay. And then, Mr. Cepeda, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report. I'm going to find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That's going to include following any treatment and recommendations for any type of mental health issues that you have. If that means going to Spinal Tap or a doctor or wherever you live, something similar to that. If they recommend that there's medication you're supposed to be on, then you will be required to take that now as a condition of probation. Follow through with any counseling and all of that so that you'll be successful in probation. Do you understand?
Yes, ma'am.
It looks like it's trying, but I'm going to hand you in just a minute the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Probation will talk to you today before you leave the courtroom and give you some documents so that you know when you're released that to go straight to the probation department so they can get you started and everything you need. Okay.
Yes, ma'am.
All right. Good luck to you, sir. Here's that. Oops, sorry.
On the back row here. Please.
Hakeem Thomas.
Hakeem Thomas. Yes.
I think that's it. Now, the ones that don't have it.
They will be off there.
I can see that. I swear.
Good morning. Are you Hakeem Thomas?
Yes.
And this is 25 DCCR 0843. Mr. Thomas is charged with aggravated robbery. What is the announcement?
Yes, in this situation, we've had several pieces of mitigating information that's come through from my client's family. I've been speaking with Ms. Mofino about this, and I think now we have a definite plan as far as going forward with this case. We're not at the point of where we want to place on the trial docket or anything, so we just would like a little opportunity to see if we can get this resolved.
Okay. One normal reset.
Yes, Judge, I believe that Mr. Thomas's parents are in town for a meeting with Mr. Lewis. I have expressed things that I would be hopeful that they would discuss that may change some of our points of view, just in order to keep the dialogue open amongst all of us. There is also a co-defendant, Mr. Hartley, in this case, who has flatly rejected any offers, of the state. So I've asked Mr. Lewis to take that into account with respect to those discussions. So a reset, I think, would be timely if the court would
Sure.
allow.
All right. I'll just do a normal reset. That way, Mr. Lewis can get everything, visit with your family, get any information, get that to Ms. Malfino, have some discussions and see where we are at that next court date.
Judge, I just want to mention, I'm talking with Ms. Mofino, I think it's a possibility that there is some more discovery that may be coming available. And so I may need a little time to, if it
Sure.
does, so I have time.
And that's the same issue we had last week with Mr. Wilkerson's client, Mr. Hartley, that we have reached out to Beaumont, have that. It's what I'm waiting on is from the out-of-county task force officers. I'll follow up again this week.
Okay. Sounds good. Thank you very much. You can go back with the bailiff.
Thank you, Judge.
Gregory Griffin.
Griffin.
Good morning, you're William Bonilla. And so, Mr. Bonilla, this is your initial appearance. You have two cases. You're on probation, and there's been a motion to revoke your probation filed in cause number 25 DCCR 0174. And you have a new indictment in cause number 25 DCCR 0719, charging you with evading arrest or detention with the use of a vehicle from May 10th of 2025. And since you've made bond in your cases, have you had an opportunity to try to hire a lawyer? Okay. Trying to see who set a bond and Oh, here it is. It's probably fine for right now. It'll get the defendant, I think. Dylan Wilkinson. Good morning. Are you Dylan Wilkinson?
Yes, ma'am.
Let's see. Mr. Wilkinson, this is your initial appearance in cause number 25 DCCR 0260. You're charged with deadly conduct, discharging a firearm from September 13th of 2024. And since you've made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am, not just yet. No, I was gonna ask if I could have a little bit more time in order to come up with more funds to hire an attorney.
So what I'll do is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice.
Cordell, Beard,
Brianna Kleinan. Brianna Kleinan. That's not one of the ones.
No response, Your Honor.
Her bond will be forfeited for non-appearance and reset at $100,000. Okay. Mark Garcia. If you'll call the name Mark Garcia. And he called.
Mark.
Let's see.
No response, Your Honor.
All right, he did call and say he was going to be late. I will issue a bond forfeiture for non-appearance and reset his bond at $100,000. If he shows up, just let me know and I'll recall that. Drayden Rose. Good morning. Are you Drayden Rose? And Mr. Rose, this is your initial appearance in cause number 25 DCCR 0789. You're charged with the 3rd-degree felony offense of assault of a security officer from April 16th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I'm in court.
How old are you?
18.
Are you still in school?
I got my GED.
You got your GED? So are you working?
I'm finding a job.
So you don't just get a court-appointed attorney. So what I'm going to do, since you made bond, I'm going to reset your case for about 30 days and do a couple things. One, you need to try to get a job first. If you get a job, bring me that information on where you're working, some kind of pay stub or just something that shows where you're working. I also want you to apply for at least 5 jobs a week. And if you don't have a job, you need to bring me where you've applied. So if you're print something out or copy something from where you've gone. And then in addition to all of that, I want you to start talking to attorneys, okay? You need to talk to at least 3. They all charge different amounts. They have different payment plans. I want you to start talking to them so that when you get a job, you can see maybe what you can afford or what you can't. If you do all that and you still can't afford an attorney, then we'll talk at the appropriate time about a court appointed. If you don't do those things that I asked you to do, then when you come back, you run the risk of me raising your bond and you would have to go back to jail for not following that court order. Do you understand all that? All right, if you'll step in front of the clerk, she'll give you a reset notice. Lance Charbino. Good morning. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino, did you get someone hired?
I did not hire him yet. It's Cody Crenshaw.
Corey?
Well, Corey, yes. Cody
Uh-huh.
Crenshaw. He asked for 4,000 down.
Okay,
And as soon as I get that, which should be about 3 weeks from now.
okay.
And then I'll be able to get him hired for.
All right. You've been here a few times, so I'm going to reset you one more time. You need to get him or someone else hired before that next court date. Again, just bring that reset notice to him. He'll tell you what to do. If it's not going to work out with Mr. Crenshaw for some reason, then talk to at least 3 others. Bring me those names. All right. Step in front of the clerk. She'll give you your reset notice. Presley Viltz. Good morning, you're Presley Viltz. Did you get someone hired, Mr. Viltz? No. Who'd you talk to? Okay, did you write down the names? Well, no, I mean, I tell you the same thing I tell everybody. Bring me back the names of the people you talk to so that I know you've tried, and then we'll discuss your options. Same words I've said for 11 years to every single person in here, so no one can ever say that I didn't say them.
Yes, ma'am.
So what part of bring me back the names of who you've talked to did you not understand?
I understood. Okay.
You just forgot. Okay, so you're in felony court. You don't just forget, because if you don't do what I asked you to, then I can put you in jail right now. I'm trying not to do that. I want you to follow the rules. It's not that hard. You have 30 days. Talk to 3 lawyers. Try to hire them. Did you talk to 3? You really talked to, so when you first answered, you said you talked to 2. So be careful what you're saying. All right. And you're probably nervous right now, and I get that, but be careful what you're saying, because you're saying some different things. I'm going to reset your case for 2 weeks. You need to talk to 3 lawyers. You need to bring me those names of who you talked to when you come back. If you've hired one of them by then, great. If not, I want you talking to at least 3. Don't wait till the last minute, because they're in court and they have things to do. So start calling today, talk to those attorneys, bring me back who they are, how much they charge. Let me know about where you're working, bring a pay stub when you come back. The more information you bring me, the better things are going to go. Does that make sense? All right, 2 weeks, step in front of the clerk. Caitlin Talmore. Good morning, you're Caitlin Talmore. And Ms. Talmore, this is your initial appearance in cause number 25 DCCR 0595. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle. And that is from April 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right. So what happens is when you're in custody in jail, we automatically give you a court-appointed attorney. Now that you've made bond, I'm going to expect you to at least try to hire your own. So what I'll do is reset your case for about 30 days to give you some time to try to hire somebody. If you do get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to go visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of those you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail. Do you understand? Yes. All right, step in front of the clerk. She'll give you your reset notice.
Fine.
Janisha Leonard. Good morning, you're Janisha Leonard. Let's See, and Ms. Leonard, you have 2 motions to revoke your probation, and then you have a new case in cause number 25 DCCR 0297. And I set bonds, and you've made bonds on all of those. And have you had an opportunity to hire a lawyer? Okay, so you need to get someone hired. The fact that I set those bonds at what I did, even when the state asked me not to, you've got some serious stuff going on. You need to try to get someone hired if you can before that next court date. So I'm going to reset your case for 30 days. You need to try to get someone hired. If you do, bring the reset notice to them. They'll tell you what to do. Go ahead. Well, you need to try to get a job first. And you need to apply to at least 5 jobs a week, and you need to bring me proof of that. Okay? If you do get a job, bring me some proof that you have a job. In the meantime, I'll also want you talking to lawyers. Bring me back the names of the lawyers you've talked to, at least 3, so I know you're trying. Bring me the information about that you're trying to get a job, and then we'll discuss all of your options. Okay? If you don't do that, then your bonds will be raised, especially on those motion to revoke probations. You'll be right back in jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. How'd you make all those bonds?
My family came to get me.
Okay, well, you might need to get with them on this too.
Yes, ma'am.
Okay. I said a bunch of bonds on motion to revokes today. I look back and I think, what was I thinking? Anthony Salvato, this is another one. Because I don't usually do all of this. All right, you're Anthony Salvato. Mr. Salvato, you're here on a motion to revoke your probation, and I set a bond in your case. Let's see, I feel like we had received some letters. You were participating in the veterans
Yes,
and all of that.
Yes, ma'am.
You're still doing all of that?
Yes, ma'am.
Good morning. What is your name for the record? Okay, and who are you with, Ms. Branch? Okay, thanks. Sorry. And so has he been following through and everything with regard to probation? Okay. Have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right. Are you working?
No, ma'am. I've been trying to do the program that we have. I have had a couple of interviews, which I have not been successful because of my record, my health diagnosis. It's been very difficult. I have attended some veteran work job fairs, and that was unsuccessful as well.
Okay.
So, but I have been traced, and I am seeing a employment counselor once a week.
Okay. What I'm going to do this morning, Mr. Salvato, and I'm looking back, I have some documentation from the Veterans Association and things like that with regard to when I set your bond. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. All right, step in front of the clerk. She'll give you that paperwork. Thanks, Ms. Branch. Sorry, I didn't recognize you. I didn't know who. I don't know if I've seen her in here. Daryl Spencer. Good morning, you're Daryl Spencer. Mr. Spencer, did you get someone hired? Did you already hire him?
I was gonna pay him today.
You're okay.
Yes, ma'am. I have money on me right now.
Okay. Did you talk to him about where you were going to meet, or?
I told him about my case and stuff like that. He told me to make a payment plan with me because I talked to Marsha Bowman and she told me she couldn't.
Okay. So you have the money to hire him?
Yes, ma'am.
All right. I'm going to reset your case 2 weeks.
Yes, ma'am.
You need to get him hired before that next court date.
Yes, ma'am.
Right. Step in front of the clerk. She'll give you a reset notice.
Yes, ma'am.
I do too. I do too. I can't remember for sure, but I think so. No, from before. I can't remember.
Let me check your share.
I know, she'll remember. I'll ask you later.
Thank you. Yes.
Yeah. I appreciate today that solid. Better choices. I wish I had said something now. He knew. He knows he went viral too. Poor thing. He might be. Somebody. I know, right? Kyle was in here. I know. I was going to try to get him first because he was being on time and patient.
Judge, if you want to find Dirk, she's not going to be here. He's in trial.
Oh, yeah.
And I have his announcements. If you want.
All right. On, let's see, Ms. Malfino's case on Dustin Knight, that's a pretrial. Mr. Gertz is not here, but his announcements.
Just read that.
I have filed and agreed.
That's
Oh,
on the
that's
other
in the other one.
That's the one I got.
Okay.
I believe she is ready, Your Honor.
Okay. And they were talking about a possible resolution last week, but they didn't do that. So if you'll get with them, her. All right, then I'm going to number, is Dustin Knight here? Did you tell him not to be here?
They didn't.
Okay.
They're not.
And then on Jesse Salinas.
We spoke, last week, Judge. Me and Mr. Gertz.
Uh-huh.
We're close, the agreement, if we'll allow us one recess, we'll be ready at that time.
Okay.
I've got all my witnesses, claiming witnesses in Florida. I've got witnesses out of state.
Okay.
But I've talked to him about it and he's all right.
I mean, they'll still be out of state next time, right?
I'm gonna say,
Okay.
but we didn't, I don't.
I mean, I didn't mean to be smarty about that. I'm just
No,
saying.
no, I understand, but we were in agreement on that. I don't think he was ready as well.
I gave you a trial.
But a quick recess.
Okay. You did, Kelly.
Yeah, we're doing the bond ones today since we're off next month.
Oh, this is for trial in 2 weeks.
I meant to call you, but your email.
Okay, I'm going to grant the motion for continuance this time in Mr. Salinas' case, but there will not be another.
Yes.
Thank you. And if you'll just relay that to Mr. Gertz
I
as
will,
well.
yes, ma'am.
Yeah, good.
Judge, can we call Mr. Mitchell's case on Van Wright?
Morning, Your Honor.
Good morning.
Judge, this was one,
John Van Wright. Good morning, sir. You're John Van Wright. And this is 24 DCCR 2485. And then there's the motion to revoke probation in 15 23582.
Judge, I know Mr. Mitchell was trying to get with Mr. Smith. He didn't realize he was out last week. He was having trouble watching the video they need to watch. I know enough about this case to know they need to watch that video.
Okay.
So I'm asking for a reset so they can do that.
Okay. I will do just a normal reset. Obviously, if there's any issues, if you can get with Mr. Nichols or Ms. Malfino, I'm sure either of them will help you work that issue out, and we'll get an
I think it just
announcement.
wouldn't play for him, so he was going to come to our office and do it.
Okay.
If he needs me to do it for him, I'll gladly do it.
Okay.
so I'm setting trial this morning in the 128th with Mr. Gertz. We're both under trial protection.
Okay.
As soon as that ends, I'll give Mr. Nichols a call.
Perfect. And Mr. Smith might be back by then as well. And so, but if not, just get with Mr. Nichols or Ms. Malfino. They'll help you out. Okay.
Thank you, Your Honor. I appreciate it.
Stay in touch with Mr. Mitchell. He'll let you know when you need to be back. Thank you. Mr. Walker, you ready on Adrian Housley sentencing?
Yes, ma'am.
Good morning.
Good morning, how are you?
Good. How about you?
Doing good.
What we're talking about, I have an intention to try and read her. That's all in this announcement document.
Oh, for next, yeah, in 2 weeks. It's one of those names that are on my list that I'm tired of seeing. It's you too, I'm sure. Good morning. Are you Adrian Housley?
Yes, ma'am.
Mr. Housley was previously in court, entered pleas of guilty to, or plea of guilty in cause number 25 DCCR 0290 to theft of property with previous convictions. It's a state jail felony. And we pleaded as, no, and there were prior offenses. And so the agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections because of the criminal history before. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Any additions or corrections?
No.
All right, Mr. Walker, you may proceed.
Judge, what I thought was going to be a long argument for us, we're actually in agreement with the PSI report, and we're asking the court to follow the recommendations and place Mr. Housley on probation.
Mr. Hoffpower?
Judge, we understand in light of what the argument is and the facts of this particular case. However, the court will leave it to the court's discretion. You see his criminal history. He has been in the penitentiary numerous times. So I leave it to the court's discretion whether or not he wants to place this individual on probation or in light of his history.
The underlying, what he ended up pleading to, was it a third or a second?
Second. 2 to 20 because it's so habitual.
That's what I wanted to make. Okay.
Yes, sir.
Okay.
And Judge, if I may,
Mm-hmm.
what we're talking about is over a 4-month span with all the items added up, we're talking about an amount that barely gets over the threshold for a Class B misdemeanor. A 62-year-old Army veteran suffers from PTSD, and as the PSI report shows, he's a low-risk candidate for it. He's not a threat to it. He's went 15 years from his last offense without getting in trouble. He's showing that he's capable of fitting in with society as well as an interest to better himself. And that's why we're going to ask that you put him on probation.
Mr. Housley, on paper, you sure don't look like you deserve probation with your criminal history. Mr. Walker is correct, and the pre-sentence report writer has stated and shown me that it looks like you really are doing well in so many ways. With your history, it just kind of is beyond me, though, that you would go and do something really as minor as what you did, knowing with your history that it doesn't matter how minor it is. At some point, you got to stop or you just keep staying in prison. Are you still working at Dragon Products?
Yes.
You've been, I mean, it looks like you're following through. You following through with your, is it the veteran services in Spindletop as well?
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Housley. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. And I'm going to order a $500 fine and order that you follow all of the rules and conditions of probation. That will include that you are on the specialized mental health caseload to help with any issues with regard to PTSD and the things that you're going through. You'll be required to follow all of their rules and conditions as well. There's kind of two sides to this, right? And so deferred probation, a lot of times people see and wonder, well, why did they give them that opportunity at not having a conviction on your record when you have all the convictions? And that's for me. It's not for you. Because now that 10-year cap is gone. I didn't send you to prison. So if you do your probation right, then you won't have this conviction. And if you're successful at the end, the case is dismissed and you will be able to continue living your life like you have been, it looks like, for the last 16 years or so.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you're back in court, you're found guilty, which means you have the conviction, and I have the entire range of punishment, which is up to 20 years.
Yes, ma'am.
And on paper, that's what it looks like you will deserve at that point if you don't take advantage of this. So I hope you do. I'm going to hand you the trial court certification that shows this was an agreement I followed, so you waived any right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
Yes, ma'am. Thank you. God
Yes,
bless.
sir. Thank you. You too, sir. Thank you, Mr. Walker.
Thank you. Excuse, Judge.
Yes, sir. Mr. Boudreaux, you've got David Holland. Mr. Boudreaux, you have David Holland.
We talked about the case, Judge.
Thank you, Mr. Coleman.
Morning, Judge.
Good morning.
Good morning, Judge.
Good morning.
You never responded to my calls of late.
Okay, we'll see if he's here.
No response.
All right, his bond will be forfeited for non-appearance and reset at 100,000.
Thank you.
Thank you. All right, thank you, sir.
Zoe and Zoe Pelosi. Thank you.
Okay. Michael White. Good morning. Are you Michael White? And Mr. White, you are on probation and cause number 23, DCCR 1117 for the third degree felony offense of driving while intoxicated, third or more. And probation sent an administrative hearing. It looks like as part of your probation, you were ordered to enter and successfully complete the safety program. And that was in order to have a scram device. When you got out of safety, it looks like you obtained the scram on April 8th, and then they notified probation that you were not meeting your financial obligations, and they terminated that, and so you don't have the scram anymore. Is that correct? So are you working? Why not? Where have you looked? What different places? Speak up, please.
Home Depot Road. Different construction company.
Okay. Has he given you notification of all of that?
He has, he also gave me an award letter from Social Security.
Okay.
He receives, I think, was it $400?
He's under review right now.
I can't hear you.
He's under review.
And that brings us to the end of another intense day in court. From a 25-year prison sentence to second chances through probation, today's hearing showed just how much a defendant's choices, criminal history, and willingness to follow the rules can shape the outcome. Some walked away with an opportunity to rebuild their lives, while others were forced to face serious consequences. But the biggest question remains, when the court gives you a second chance, do you actually take it? Let us know your thoughts in the comments. And if you want more real courtroom moments and legal breakdowns, make sure to like, subscribe, and stay tuned for the next case.